Representative Brady,
Here.
Representative Breton,
Here.
Representative Chestek,
Excused.
Representative Filer, Representative Kelly,
Here.
Representative Lean,
Here.
Representative Singh,
Excused.
Representative Webb,
Here.
Chairman Washut.
Representative Singh is present, and so am I.
You have a quorum.
Thank you. Welcome, everyone, to House Judiciary. Today, we are going to start with Senate File 115. Senator Nethercott, it's all yours.
Well, good morning, House Judiciary. It's good to be with you. Good representatives, you have in front of you Senate File 115, Judicial Review of Agency Actions Limitations. So what does this bill do and why is it in front of you? This bill relates to, as you can see on page 1, Wyoming Statute 16.3.114. And this is a statute that allows for judicial review of agency actions. And so those typical agency actions that this statute is dealing with are those of, say, a county commissioners that deny some type of zoning permit. And that allows the applicant who was denied to appeal that decision to the district court because they suffered from an adverse action. That's its typical usage. I mean, any other type of general agency action, if the individual suffered an adverse event, they can appeal to the district court. So, but what has been happening in the land of public employment is that when employees are experiencing, let's say, a written reprimand from their public employer, they have been appealing that adverse event to the district court for judicial review. And it's my view that that isn't exactly what this statute intended, was to be an arbiter of public employment decisions. I want to make sure it's clear that those public employees who have the right to appeal a termination decision, that still exists, and we're not interfering with any of those rights that those employees had. But what we are doing is providing clarification for anything less than that, and where the employee didn't have those rights, that they don't get to avail themselves of any type of corrective action that they may experience in their public employment to the district court. And so where is that? And even though this bill is 3 pages long, really there's only one change that's happening to this statute, in addition to kind of a restructuring to what's already there for clarity. And that's found on page 3, lines 7 through 9. This is the bill, and this is why it's here. And that says the right of judicial review under this subsection shall not apply to any action or inaction taken in regards to the public employment of a person, and unless they have those rights, as I previously mentioned. They can appeal in a contested case action, or it's otherwise provided by law. So that is the bill. The other changes that you see are essentially just a restructuring of the statute. I brought a copy of the statute as currently written, so you can see what it looks like in the event you're interested. But going back to page 1, page 2, that language is already in statute, but we've just restructured it in a way that it's less of a massive run-on sentence. And it's easier to see what the original statutory language looks like in comparison. And I'm happy to hand that out if you're interested. So, Mr. Chairman, that's the bill. I think this is good for both employers and employees. We don't want employees to be working in an environment where anytime corrective action is needed, that the employer has to paper the file in anticipation of going to court to have their decisions for corrective action questioned by a judge that may not know the full scope. For example, an employee who receives maybe a written reprimand, it's just relating to that incident. The employer doesn't want to turn it into something bigger, but if their decision's going to be questioned by a court and they have to show that there's all this evidence and a record on appeal, then they're going to do that, and they're going to put the employee's entire personnel file in there, bring up every bad behavior that ever happened, just so they can justify maybe that one point of corrective action in that moment. I think it's good for employers to know that they can just take that corrective action, know that every decision won't be challenged, and it just allows for a more flexible, healthy work environment. Thank you, Mr. Chairman.
Thank you, Senator. How frequently are we seeing these types of cases show up in district court?
Mr. Chairman, not often, but I would say probably once or twice a year, but it results in pretty solid dysfunction for the public employer.
Committee, any questions for Senator? Representative Lean?
Thank you, Mr. Chairman. Thank you for coming today, Senator. My question is, under the current statutes, would anyone be able to obtain judicial review in regards for public employment, or are there any statutes providing for review of public employment actions?
Senator?
Yes, Mr. Chairman, Representative, there are numerous statutes that deal with the rights of public employees. One of those would be county sheriffs. There's a specific statutory section related to those. There's separate statutory sections related to city police departments. There are separate statutory sections related to public teachers, and they have different rights associated with those different professions. And then many public employers also provide employment rights. Thus, you can only be terminated for just cause. That then triggers what are called due process property interests, because the government has granted those rights. And then due process attaches, and that public employee can only be terminated for cause with a process, notice and a right to a hearing, which is what's called a contested case.
Representative Kelly?
Thank you, Mr. Chairman. One thing I like to do is make sure that I understand what we're doing here in plain language. The current statute has an unforeseen loophole where a public employee could potentially go right to court for, say, feeling unfairly passed over for a promotion. So what we're doing here is they're not losing their right to go to court. It's just making sure that they've exhausted all other remedies, that they've taken all other avenues before they start clogging up the courts with something like that. And this is also to prevent the employers from having to keep tedious records and being on top of everything documented at all times because of this potential for a snap judgment lawsuit.
Senator?
Mr. Chairman, that is correct. Yes, I think it is a bit of a loophole. I struggled with how to describe it. I think it's just a misapplication of the intent of the law in that it's not intended to be a remedy for public employees who have a bad day than to go to the court and turn it into litigation. And it's not a lawsuit against the public employer. It is this appeal. It is this right of review to evaluate those decisions. So it's kind of at this unique area in the law. But you're absolutely right, Representative. We're just kind of narrowing that down to when those rights are truly affected and employment would be in question.
Senator, can you give me an estimate of the cost when an employee appeals a written reprimand to district court for review? What's the cost to the government agency and to the court time and so forth?
Mr. Chairman, thank you. Most government agencies don't have in-house attorneys that go to court. They have in-house attorneys, if they have in-house attorneys, they're kind of advising internally on what they do. So most often they have to retain outside counsel. Then that outside counsel costs an hourly rate. For a case like this is going to cost anywhere between probably $5,000 to $20,000.
Thank you. Further questions? Representative Lean?
Thank you, Mr. Chairman. Senator, could this limit one person's access to the courts? And if so, why would we limit the review of an unelected agency's actions?
Senator?
Mr. Chairman, well, I think you're assuming that they are an unelected agency. This applies to all public employers. So this includes the counties. This includes those elected boards of a hospital district or a cemetery district or a college. And so I don't think it's fair to say this unelected agency, this bureaucrat, how could we give them this power? We want government to run efficiently, and we want employees to be held accountable to those taxpayers. And every time an employer or a manager has to go to court in order to provide corrective action, that's not the efficient administration of government, regardless of whether or not they're elected or not. If you want government to act more like a business, this would be it. Again, because if you want to put an employee on a performance improvement plan, that may be considered an adverse action, and then we're going to appeal that to the district court for the judge who has no understanding of this employee's background, history, all of the facts associated with the performance improvement plan, because there's not this huge record on appeal that gets created. We certainly can be if we continue down this course and really make life very difficult for public employees. But the judge really isn't in a good position either to understand why this was done. In these actions, the employee and the employer don't get to testify. There's no depositions taken or a trial-like hearing. It's just this review. So you submit to the court the letter of reprimand and maybe a response, and then the judge gets to second guess that. So unless the employer has put in that letter of reprimand, all of the reasons with this full analysis, this employee was hired on this date, in this position, this is their salary and compensation, this is how they failed every time, this is why I think a written reprimand is appropriate, these are the potential outcomes, for that judge to say, yeah, I think maybe if I were in the shoes of this manager for this department with the challenges this department's facing, this might be okay. And it's just not really the proper role, I think, of our courts to second guess maybe a manager's decision concerning an important corrective action needed for an employee. And again, this is for written reprimands, right? This is for something less than termination. So the employee's job is not in jeopardy typically in that point. Certainly there's an argument could be made that that is maybe possible down the road, but that particular action for which they're appealing to the district court is not an action where they're losing their job or losing their compensation or losing any right. It's just corrective action that we are limiting their ability for a judge to second guess their manager's decision.
Senator, would this misinterpretation of the law supersede municipal or county policy manuals that guide employee actions? Does this supersede that so that they can ignore the manual and go right to court?
Mr. Chairman, in certain circumstances, yes. This law does not replace the personnel manuals associated with those employees. However, once they experience that adverse action, they can go straight to the district court for review, and they do.
Further question? Representative Webb.
Thank you for being here, Senator. Mr. Chairman, I guess my question is are we limiting the local public entities' rights by doing something by passing this bill?
Senator?
Mr. Chairman, no, not at all. I think you're empowering their rights so that they can effectively manage and run their organizations. So I think arguably the opposite of limiting their rights.
Representative Bratton?
Thank you, Mr. Chairman. Is a contested case basically the same thing as a termination?
Senator?
Mr. Chairman, no, this bill does not affect contested cases. So there are public employees who have property rights to their jobs, and therefore they cannot be terminated without just cause and notice and opportunity for a hearing. That opportunity for a hearing is what we call a contested case. In each public government entity in the state, and there's different, both state level and local government level have different types of contested cases that they may administer, subject to the Wyoming Administrative Procedures Act. That is a trial-like hearing at the administrative level. And the decision makers at that level vary depending on the government entity. It may be your county commissioners in the case of the sheriff's department. It may be the board of trustees for a community college. It may be the sheriff in a sheriff's office case. It's very dependent on the local agency or entity. Then after that trial-like administrative hearing, that employee then, depending on the outcome of that decision, can then appeal that again to the court. And they don't lose that right in this bill to appeal that decision to the court. That is protected here. It's just those low-level, doesn't affect any property rights, the written reprimand scenario, right? You get a reprimand, you're not losing your job, you're not losing your compensation. If you're being recommended for termination, all those rights still exist, and that bill doesn't affect that. This bill doesn't affect that.
Further questions?
Mr. Chairman, I would just say, having looked at what's in Senate Judiciary this morning or today, is the bill that the House passed out concerning giving full authority to the 5 statewide electeds to terminate at will and to transform all those employees to at will. So if you support that bill and you support the right for the 5 statewide electeds to run their departments as they see fit and to terminate at will, this bill is like very, very insignificant compared to that you supported and passed out.
Okay. Do you have other witnesses with you this morning, or?
No, Mr. Chairman, I try not to turn them into big events. I just try to bring good legislation and explain the why, knowing the time is important here, Mr. Chairman.
Thank you, Senator. Please hang close if you can. We may have further questions after we take public comment. Anyone in the room wishing to testify on Senate File 115? Really? All right. Anybody on Zoom for 115? So with that, we will close public comment. Senator, you want to give us a wrap up?
No, Mr. Chairman, this is it. I do think this is a clarifying correction to the law, and it isn't affecting anyone's rights, and it's a good solution, and it's, I think, helps save our government entities money and helps provide a healthier workplace for those employees as well. I really do think it's a good win all around and provides necessary clarity to our statutes. So thank you, Mr. Chairman.
Thank you, Senator. Committee, what's your preference? Moved by Representative Kelly, second by Filer. Discussion on the bill, any amendments to the bill? Representative Lean?
I don't have an amendment, so if you're going to propose one, I'll
Let's
let
do amendments first. Anybody have amendments? Seeing no amendments, any comments on the bill? Representative Lane.
Thank you, Mr. Chairman. I just think that this is creating an exception with the exhaustion requirement, and that even if people do exhaust all of their remedies, that we're ultimately putting them in a position where they're taking away some of their valuable information, and we're giving the judge, we're saying that a judge doesn't have the ability to know what's going on. But I don't believe that that's true. I believe that this legislation is impeding on rights. And with that, I ask for a no vote.
Others? Representative Kelly.
Thank you, Mr. Chairman. This looks to me like a simple, common sense solution to some potential bureaucratic backlogs. And as somebody who has worked in the public sector before and has been stuck with endless amounts of documentation at a different level, but having to document every single thing a student with special needs does in case we ever had any administrative proceedings, that something like this would allow a public agency to just relax a little more and do their job and not worry about looming litigation over something potentially very minor. So I'm in favor of this.
Further comment? I'll just say, in my days as a police administrator, we had pretty clear civil service rules that spelled out the process, and low-level types of corrective actions like reprimands and written reprimands and so forth were intended to help get employees on the right track, to give them fair notice that you're not performing up to standard. Here's what you need to do to correct that. You know, please improve. Supervisors would get it. I just can't imagine what that would have been like had written reprimands been appealed to the district court. You know, we worry about government efficiency and effectiveness and all that. And if you've got employees who are taking simple reprimands to the district court level, makes it really tough to supervise employees and make them effective and efficient. And if you've ever had to work with a less than ideal employee and your boss is trying to correct them, working with those problematic employees usually ends up putting a lot more work on you because the guy in the next cubicle isn't pulling his weight. And that's what supervisors try to do with reprimands and improvement plans and those sorts of things. And I just can't see why we would ever want those to be resolved at the district court level unless we're getting ready to terminate somebody, and then we can have that contested case before the court. Representative Filer, is there any interest in?
Yes, Mr. Chairman. Actually, I think this creates a little more equitability with the employer and the employee too. But just to kind of give a little background too, just like you did, Mr. Chairman, being a police chief, in the military, we have almost the same process when I was in the military. So if we reprimand somebody for something, it goes in a file called a PIF, and it's in there forever. So if you just entrust your supervisor to write up a reprimand, and it goes in your PIF, and you have no action as the airman or the lower ranking employee to be able to fight that, to get that maybe out of your personnel file in some way, and at least be able to tell your story if you feel unjust. So I think this creates more of a equitability between both, and as we all know, with being a right to work state too, with our public employees in the private sector, an employee can take their employer to court for unjust. So I think this creates equitability all the way across the board, Mr. Chairman.
Further comments? Representative Brady.
Well, just a thought. Do you think this might create supervisors or whatever be less, or let's say apprehensive to even want to correct one of their employees, thinking that it's probably going to be taken to a court and there'll be less power away from the supervisor, if you get what I'm saying? Because the employee can always run.
I think just the opposite, you know, that if employees believe and there's a avenue in the law as presently interpreted, that they can take every minor personnel action to the district court level. If I'm the supervisor, I think I become less interested in correcting their poor behavior. Yeah. Representative Webb.
I'd just like to have you review the conversation that went on about superseding the local entity's policy manual. I don't know that I'm clear on that and what type of an effect this might have on it.
Yeah, you know, if the law allows something, the personnel manual can't preempt that. And so if the understanding of the law as written today is that employees can take these cases to district court, even though the personnel manual says something different, the employer can't stop it from going to district court. That's the purpose of the bill, is to say we're taking away that interpretation of the law so that the personnel manual of the agency will determine the avenue of appeal available to employees who receive low-level misconduct. Did I state that right, Senator?
Mr. Chairman, thank you for the opportunity. This bill does not affect any government entity's personnel policies. Those personnel policies are still in effect and work as intended. I want to make sure there's no confusion, because what you see on page 1 and the striking of the language subject to the requirement that administrative remedies be exhausted, that language is not being stricken from the statute. It's just being moved to a different location to restructure the statute for clarity. That's why I provided the original statute for you. And if you go to page 3, lines 1 through 2, that language is you see appear again. So the requirement for an employee to exhaust their administrative remedies still exists, and those administrative remedies apply. In the circumstance associated with a written reprimand or some low level of discipline, there typically is an administrative remedy. It's just limited, where the employee gets to file a response in their personnel file. But it isn't a full contested case hearing every time they get a written reprimand or some full significant process. It's a truncated version. So they're still required to do that process before they can appeal to the district court to judge that. But the reason why it's kind of nonsensical and why we're, I think, providing corrective clarity to the statute is when you're talking about low-level discipline or somebody receives an oral reprimand, right? A verbal counseling session, hey, can you come to my office? I want to talk to you about this. And it's a corrective counseling that occurs or maybe is documented in some form, that employee can't just go to the district court and say, what happened to me was wrong, judge, don't you agree? And the court doesn't have, that's not good employment practices for anybody to do that. It's not taking any rights away, though, from the government entity or any of those personnel policies whatsoever.
Thank you for the clarification. Representative Feiler.
Yes, Mr. Chairman, and I believe Senator Nethercott hit the nail on the head. I think that all administrative remedies shall exhaust before a person seeks that. So there's a lot of personnel rules maybe, or a manual that, in all of our municipalities that most employees have to sign that they got to follow. And, if there's a reprimand of any type, I'm sure there's ways to move that up the chain and before this ever goes to a court or a judicial review. So, I don't see anywhere in this legislation where it would ever take the right away from the municipality or the public employer to oversee or supersede their personnel rules.
That was always my understanding, and so I was a little surprised to hear that district courts are hearing these types of cases. That it's always my understanding that employees would exhaust the administrative avenues available for them before they could take it into the district court. So, any last comments from the committee? There's no amendments. Here, you want to call the roll on Senate File 115?
Representative Brady,
I'm thinking no.
Representative Breton,
No.
Representative Chestick,
Aye.
Representative Feiler,
Aye.
Representative Kelly,
Aye.
Representative Lean,
No.
Representative Singh,
Aye.
Representative Webb,
No.
Chairman Washut.
Aye.
5 ayes, 4 noes, do pass.
All right. Senator, do you have somebody lined up to manage this on the floor, or do you want somebody from the committee to manage it?
I will have one of the co-sponsors manage it, but for those of you that heard the testimony, I would appreciate any help to maybe clarify some of those potential concerns. Thank you.
Thank you. And I'd encourage any committee members, if you have further questions, to please reach out to the good senator. Maybe things weren't particularly clear. All right, so that takes us through 115. Our next bill for our consideration is Senate File 160. Want to go see if you can find Senator Crago? I saw Senator Olson go by, but. So we'll just pause for a couple minutes here while we get the sponsor from adjacent committee room, and we'll just stand at ease. Mr. Chairman, you want to come on up? You can bring whatever backup you need. Own a friend. Good morning, welcome to House Judiciary. We're back in session. We'll take up Senate File 160. Chairman Olson.
Thank you, Mr. Chairman. It's a pleasure to be in front of House Judiciary, a committee that I had the pleasure of chairing at one point in time in my legislative time. So it's nice to be back in front of and see some of the members that served on that committee with me. Mr. Chairman, I bring you what is Senate File 160, Treatment Courts Amendments. And this bill, what it does is it allows for the creation of mental health diversion programs. So what exists today currently is one pilot program for mental health diversion in Campbell County. There are two more that are coming online in Natrona and then here in Laramie County, my county. The goal is actually really simple. It is individuals who have come across law enforcement, they've made contact with law enforcement because of whatever it may be, but they have an underlying mental health condition. The goal is to put them into a treatment court and divert them from the traditional system, get them the treatment that they need to treat their mental illness, and then maybe serve some probation, but not time in jail necessarily. The goal is to reduce recidivism, which is what treatment courts do when it comes to substance abuse or substance use disorders, but also to mental health disorders. This would also reduce the number of people that get sent to the state hospital. You'll notice in this bill, there is no appropriation. It's absorbed by the courts. I think that's really important to note that there's no growth in government occurring by an expenditure. This bill also does two other things. So that's the primary thing it does is the mental health diversion. That's the most important thing I think about this bill, but it does do two minor things as well. It allows for current drug treatment courts to take individuals across county lines. That's important because there may not be bed space available, or there may not be programs, frankly, available in certain counties. And then lastly, from basically page, I think it's 13 on in this bill. The reason why this is so lengthy is because half of the bill goes into the statutes and updates substance use disorder to from substance abuse, changing the language to substance use disorder. So that's really half the bill. Mr. Chairman, that is the bill.
Mr. Chairman, can you explain the rationale behind changing that term from substance abuse to substance use disorder? I understand that has something to do with the National Institute of Drug Abuse, and that this is now the terminology that's state of the art or something.
I'm gonna punt already.
Ms. Butler?
I know it's a term of art.
Mr. Chairman, I think you hit the nail on the head. This is the language that is used nationwide now by mental health care providers throughout the United States. Rather than substance abuse, they have shifted to substance use disorder. I am not a mental health professional, but there are a few in the room, I believe, who can help with that question if you'd like more clarification around that.
Thank you. And that happens from time to time, right? Professions change terminology that becomes, I think sometimes I think back to, I don't even know if you should say the word, but we used to use the word retarded in statute, and we used to use it commonly in school settings and all sorts of other places. And then people thought better of the term, and we've moved away from that terminology, and something similar taking place here. We had one term that was used for several decades, and now the people in that profession have opted for a different term. I see a few head bobs. We might get some testimony here in a minute. So, further questions on the bill? Representative Lane.
Thank you, Mr. Chairman. My question is about the fiscal note. It says that there's an indeterminable due to an unknown number of cases. And so I'm curious at what we're looking at when it comes to expanding this program across county lines and for different districts. What does that cost look like?
So,
Chairman?
Mr. Chairman, Representative Lean, I will let the courts expand upon this, but I believe you have a sheriff online, is what I heard, who will be able to talk to at least what it looks like in that individual county. Each county is going to be a little bit different in terms of the cost, but there's no state cost, which is why you don't have a fiscal note. There's no cost to the general fund or other budgets of the state of Wyoming. Obviously, there would be a cost to counties, and I'll let Ms. Butler expand upon all of that.
Ms. Butler?
Mr. Chairman, Representative Lean, so the way that treatment courts are funded, they're funded from a few different sources, and one is through state funds. And so those state funds come into the judicial branch budget, and then we grant those out to treatment courts throughout the state. So they apply for funding based on the number of beds that they have, and then we have that fund that we use to grant out, depending on how much is in that fund. So we get an appropriation. There's also some tobacco funds that come in that we use to grant out to treatment courts. So that's one funding mechanism. And as Senator Olson explained, there is no ask from the general fund at this point. The other portion comes from the counties themselves. So there's additional funding that comes into those treatment courts through the counties, because most often the counties are the ones who are the creating entities of those treatment courts. You can have a 501c3 that creates a treatment court, but in Wyoming, the vast majority are made through the counties, they're county entities. So you have the funding source of grants that we provide through the judicial branch, and that is from general fund partially from tobacco trust funds. And then you have county funding that comes into those treatment courts as well. So there's a couple of different funding sources there. Mr. Chairman, and I'm not sure if that was responsive to the question, but I'd be happy to answer any other questions.
Follow up?
Thank you, Mr. Chairman. In addition to that, I would ask, in the next budget session, what would you anticipate the judicial ask to be to cover this?
Ms. Butler?
Mr. Chairman, Representative Lean, I don't think there will be any increase at this point. And I can't tell you, 10 years into the future what that could look like, because quite frankly, the funding sources, the funding for treatment courts, it grows. I mean, and treatment courts are incredibly effective, and they, the amount that we spend on treatment courts is pennies on the dollar to the amount that we spend to incarcerate individuals. And so I can't tell you that in 10 years that won't grow, but I don't anticipate any additional funding requests like in the next budget session.
And Ms. Butler, is it clear that this extension of authority to take people from across county lines, it's still discretionary, right? So if a program is full, they can tell another county, we can't take anybody. Is that my understanding is correct?
Mr. Chairman, that is correct. Everything that the treatment court does is within their discretion. So there's a treatment court team within each treatment court that includes a number of different stakeholders. So that would include the prosecutor, the judge, a public defender of some sort, usually the provider, and the treatment court coordinator. And so they are all meeting regularly when there is an application for someone to become part of a treatment court or a referral, and they make that determination whether or not they are going to accept that person. And Mr. Chairman, I would just mention that we have Judge Sean Chambers here today, and he does run a treatment court here in Laramie County. He's a circuit court judge here, and I'm sure he'd be happy to answer any questions along those lines as well.
And Mr. Chairman,
Yes, ma'am.
just for the committee's edification, your question in the bill is on page 8. There's a subsection D, specifically says that a participant doesn't have a right to the program, nor does the act obligate a program team to accept any proposed participant. So I just wanted to make sure you knew where that was in the bill, in case, if this bill does move forward and you get that exact question on the floor, then you know where to locate that.
Thank you much. Representative Chester?
Thank you, Mr. Chairman. And for Ms. Butler, I think you alluded to this a minute ago, but I want to get a little more clarification. Do you have any general sense of the relative cost between treatment programs per inmate versus incarcerating an offender?
Is there a trade-off, Ms. Butler?
Mr. Chairman, Representative Chestick, I don't have those numbers in front of me, but I do know that study has been done. And I think possibly either Director Johansson or Ms. Somerville may have those numbers, but I believe it's like, it truly is pennies on the dollar. The effectiveness of treatment court as opposed to, so the amount that we spend on treatment court as opposed to the amount that we spend to incarcerate individuals.
Okay. Further question, Representative Kelly.
Thank you, Mr. Chairman. This is, I apologize in advance, it's kind of a big question. This is a familiar issue we've seen before, and looking at the statute, it talks about mental illness being described as it is already in statute, including a disorder or disturbance of behavior, feeling, thinking, and judgment to an extent that care or treatment are required. One of my concerns in the past is that we would have this program open up to anyone, a repeat offender who shoplifts, saying he is antisocial personality disorder and trying to avoid a conviction. So looking through the statute here, I see nothing in the program nor anything herein contained shall be construed as limiting the discretion of the prosecuting attorney in regard to the prosecution of any criminal or juvenile case, which is good for me, because that tells me that a prosecutor typically has the incentive to win cases and make prosecutions, so they wouldn't take that lightly, that it's up to the prosecutor whether or not somebody should qualify for this. So my question that I'm finally getting to is, this is nothing in this bill, but are you aware of anything else in statute that might limit the prosecutor's discretion?
Ms. Butler.
Mr. Chairman, Representative Kelly, the short answer to that is no. I would also add that, we have, so this is the substantive law that you're looking at today, but there are also court rules that are geared toward both treatment courts and diversion. And in the diversion track, the prosecutor is required to consent. So they have the ability to say, nope, this person is not going to diversion. This is not a good candidate for that. And so they have the ability to basically look through, the people who are referred to diversion and say, we're not going to do it this time. And then that will take that person entirely out of eligibility to participate within diversion.
Representative Bratton.
Thank you, Mr. Chairman. Could you speak to the pilot project? Tell us more about the pilot project that was in Campbell County.
Ms. Butler.
Mr. Chairman, Representative Bratton, so the pilot project began in Campbell County a little over a year ago. It began in January of 2024. So it seems like a long time, but it is still very much in its infancy. And so there have been a number of referrals to that program. There were 2, I believe, that were accepted. There was 1 that has graduated. And so I think, one of the things that we've learned out of this pilot program is the folks who are accepted, and there are a number of steps that you have to go through in order to be accepted to diversion. And so the folks who finally get to that acceptance, they are people who need a lot of service and a lot of time to be able to be successful. And so I think that's one of the pieces that we're learning. That person who did graduate, it seems like a small number, but based on the amount of time that we've saved just in that person being in and out of jail is substantial. And the cost that was equated with them being in jail for, hundreds of days prior to coming to the project, and then after graduating, not have gone back into jail at all, I think is indicative of how much help this program could provide. I would also say, as we look to expand to larger counties and counties with more services, I think that will grow. So looking at Laramie County and Natrona County, one of the advantages in both of those counties is there are places for inpatient treatment in both of those counties. That's not necessarily true for Campbell County. So often if you have to stabilize somebody in Campbell County, they go representative to your county, to Sheridan County to be stabilized, and then they go back to Campbell County. So that creates a little bit of a hiccup. And so looking at larger areas that have more of those services, I think we will see many more people who are eligible to come in. I think in talking with Laramie County, the sheriff, Sheriff Kozak here indicates that he has up to 25 people who he thinks could be eligible today for this diversion program. So, we're still in infancy, we're learning a lot, and that's why it's still a pilot, is that we will learn as we go along. And I think as we expand, we'll see many more, much more data that is indicative of the help that we can provide to these folks.
Senator Olson, I saw in the digest that this bill was very popular on the Senate side of the building. There were only 4 no votes. What were some of the concerns, if there were any, expressed on your end of the building with regards to this bill? I think it was 27-4 on the vote.
Mr. Chairman, you are absolutely correct. It was very popular going through committee and through the floor. I don't recall any specific concerns that were raised by those no votes. What I will say is that the discussion centered around the need for this program to expedite and get this program off and running. I think, Ms. Butler highlighting just how many people could be eligible in my county alone is reason enough to move it forward. So there really wasn't a lot of negative discussion, I would say.
Representative Bratton.
Thank you, Mr. Chairman. So I actually listened to the Judiciary, the Senate Judiciary, and there were questions about the money and the expanded population that would be eligible for this. A couple senators asked, we're very concerned about that. Also, the criteria for eligibility of the program was a big question in the Senate Judiciary. And I know that you also spoke to that. Ms. Campbell, would you, Mr. Chairman, to Ms. Campbell, if she would, or Ms. Butler, sorry, if you would comment about the criteria for the eligibility that was in the Florida program that the people went down and observed, and also the Campbell County program. Could you speak to that, the criteria for eligibility?
Mr. Chairman, Representative Bratton, I'm going to try to answer that, but if I'm not responsive, please feel free to correct me. So in order to be eligible for the program, there are a number, as I said, there are a number of steps that somebody would have to go through. So the people who are eligible are low-level misdemeanors, right? So nonviolent misdemeanors, things like trespass, disturbing the peace is something of that level of crime. And then they have to suffer from a mental illness. And so pursuant to our current rules, it's a serious mental illness. And so they have to be diagnosed with that serious mental illness. So what will happen is there's usually an encounter, and what the law enforcement picks them up, and they are generally charged at this point. That's how it works in Campbell County. And so once they're charged, either the public defender or the prosecutor or the judge, as they see this person, will recognize that there is a mental health issue going on, and they will be referred. A lot of times if they're booked into jail, the jail will do the initial screening to determine if there is a mental illness or an indication that there is a mental illness. And then if there is, they'll have to go through a much more extensive evaluation with a mental health professional. So those are provided by, currently in Campbell County, by our community mental health provider, which is VOA in Campbell County. And so they go through this extensive mental health screening, and they are diagnosed with a mental illness. And usually, as I said, one of those serious mental illnesses, which would include schizophrenia, schizoaffective. Let me just read those out for you. My apologies. Schizophrenia, schizoaffective, bipolar, major depression, and post-traumatic stress disorder. And so if they're diagnosed with one of those disorders, those mental illnesses, then they are referred to the treatment court team. The treatment court team has the opportunity to determine whether or not they're going to accept that person into the program. As I said, there's also a piece in there with diversion where the prosecutor has the opportunity to say, nope, I'm not going to give my consent to this person participating in diversion. So they have the opportunity, the prosecutor essentially has the opportunity to put an end to that person's eligibility. And then they go through the program, they meet with the judge every so often. I'd say, I think it's once every 2 weeks in Campbell County right now. And then they get pretty major case management support and mental illness support from the providers, the community mental health providers, and then also from the treatment court team itself who does some case management for that participant. So, Mr. Chairman, I'd be happy to answer any questions if that did not answer.
We're coming up on 8:30. I know there are other people in the room wanting to testify. I want you two to stay close because we might come back to you with some more follow-ups, but I'm thinking maybe some of the other folks might clarify some things as we move on. So let's bring in Sheriff Harlan, Judge Chambers, Mr. Johansson, Ms. Somerville. Let's get some of the agency folks up here, and we'll bring in the sheriff from Natrona County. Good morning, Sheriff. Can you hear me? Sheriff Harlan, are you there? There he is. Good morning, Sheriff.
Good morning, Mr. Chairman, committee members. My name is John Harlan. I'm the Natrona County Sheriff. I apologize for the little time delay there. But today I'm speaking on Senate File 160 in support of. There's been quite a bit of good testimony this morning, probably far more articulate than I can provide you. But what I would like to do is share that we are eagerly anticipating the launch of our diversion court program here in Natrona County. I know it's still early in the morning, but I'll give you a few numbers, some statistics to chew on to kind of give you some context of what we're talking about. Natrona County has one of, if not the largest jails in Wyoming, with a total capacity of 476 beds. In 2024, our average daily population was 258 people. So around 32% of those on the average daily population, 32% are under a provider's care and prescribed psychiatric medications. That's 82 inmates. So I'll jump back real quick to 2021. I took a high-level view of where people were at in our detention center and how they were traveling through the criminal justice system. And there was a couple areas of concern that I had. And those were specifically two areas that had to do with inmates that suffered from severe mental illness. And so the criminal justice system has constitutional protections in there, which are extremely important. But essentially, the criminal justice system creates its own constitutional conundrum, a catch-22. Sometimes when the criminal justice system and the mental health system are working effectively and efficiently, that process is great. What we found was people in our custody were getting stuck in the system and waiting prolonged periods to go to the state hospital. When I first started looking at this, the average wait for someone who was committed to the state hospital for evaluation or restoration was around 240 days. In 2024, I saw an average that was quite a bit less than that, around 160 days. But still, that's a considerable amount of time. And those are people that are waiting to either establish their competency to stand trial or have their competency restored. And again, that's one of those constitutional protections that is in place before a trial actually starts. So not only is that not right to get somebody stuck into the system, but dollars and cents wise, let me tell you what that equates to the taxpayers of Natrona County. In 2024, we saw 8 inmates that were committed to the state hospital for restoration or evaluation. And 4 of those inmates have already gone through the process. 4 more are still waiting their time. The total cost of housing those inmates so far has been $160,230. That's a lot of money. And we are talking about 8 inmates that would fit into a diversion program. Low-level misdemeanors. All of them are criminal trespass, breach of peace, which is disturbance, misdemeanor possession of controlled substance, have 1 for a couple traffic violations mixed into that. So that's a big chunk of money, and that's not all inclusive. We also have medication cost, extra medical cost, and this is all before the person has even gone to trial. So these are low-level misdemeanors. And essentially, we're talking about crimes whose statutory limit for incarceration is 6 months. And they're spending far longer than that just waiting to go to the state hospital. And the fines are also capped at $750 for most of these offenses. And yet we're spending over $50,000 a year to house them while they're waiting. So essentially, there's a lot of benefit to a diversion program. And we're hoping that we can pick out a few of these people out of the system with each one of these programs, whether it's post-adjudication mental health treatment program or a pre-adjudication diversion court process. I think the end result, pick a few out for with each program a year, and we're going to save the taxpayers a lot of money and actually address what the root cause is for their violation of state statute, for their committing of crimes. We're talking about people that because of their severe mental illness, they are not behaving appropriately in public. Therefore, they are violating the letter of the law. But the way the process is set up now, they go through this mental health evaluation process, through the restoration or the evaluation of competency. They are either sentenced or found non-competent, and they are released from custody. And that extensive amount of time that we've invested into that person, that extreme amount of taxpayer dollars that we've invested, has not addressed the root cause. So essentially, we just rinse and repeat over and over, and the problem is never being addressed. So this is a very effective means to do that. There's been a lot of work that has happened with your partners in the legislature. The 3 branches of government have analyzed and talked with the public around the state about these issues and potential solutions. And although diversion courts have worked very well in other parts of the United States, this really is a Wyoming solution developed by people from Wyoming. So, Mr. Chairman, thank you. I will try to be respectful of your time, but I stand for questions.
Thank you for being here, Sheriff. Representative Kelly.
Thank you, Mr. Chairman. And thank you for that comprehensive presentation of the issue. I'd like to ask you, if you could please, to illustrate explicitly some of the behaviors exhibited by those incarcerated with severe mental illness and the effects that has both on fellow inmates and those who are employed at the jail.
Sheriff.
Mr. Chairman, Representative Kelly, thank you for that question. Essentially, when a lot of what we're talking about specifically with candidates that would go to mental health treatment court or diversion court, these are high needs, high maintenance inmates. We're talking about behaviors when they come into the jail, they're in a period of crisis. We're talking about behaviors that could be short-term or long-term during their duration of the stay at the jail. You know, explicitly, we're talking about self-harm, trying to harm themselves, defecating on themselves, playing with their defecation, hallucinations, things that really need to be addressed in a clinical environment, psychiatric environment. We do have capabilities at the jail to stabilize somebody in crisis, but the treatment aspect is not there. That's not the appropriate place for psychiatric treatment at a jail. So these are very severe behaviors. They are time intensive, they are labor intensive, and quite frankly, they're dangerous. So these behaviors contribute to the inmate harming themselves. If there's a need to correct their behaviors or keep them safe by using force, that presents a safety risk for my staff and also the facility itself. There's quite a bit of facility damage and breaking of things because they are acutely in mental health crisis. Hopefully that answers your questions. I can get more detailed if you like. Mr. Chairman, thank you.
Thank you. I think that was quite responsive. Representative Bratton.
Thank you, Mr. Chairman. Thank you for being online with us, Sheriff. So of the maybe 25 people that are eligible in for your program, do you think they would all meet the severe mental illness definition as being used, or that's being used in Florida in Campbell County? Those are the schizophrenic, schizoaffective, major depressive, PTSD, bipolar.
Sheriff.
Mr. Chairman, Representative Bratton, thank you for the question. Yes, ma'am, I do. If not all, most of them. We're operating under the same court rules that Campbell County is, and really, we know these folks because of their severe mental illness. They come into law enforcement contact on a regular basis, if not at least once or twice before. These are names that we're familiar with. We know them, and most of these folks, when they're stabilized, they're good people and they're contributing citizens, and that's where we want to get them back to. So to answer your question, yes, I do think so. If not all of them, certainly most of them.
Thank you.
Thank you, Sheriff. All right, let's hear from Laramie County. Sheriff, hang tight. We may come back to you if you have time.
I will, Mr. Chairman. Thank you.
Thank you. Mr. Mull.
Mr. Chairman, members of the committee, Laramie County Commissioner Gunnar Malm here on behalf of the Wyoming County Commissioners Association in support of this bill. I will just note quickly that this is a fiscally responsible response and a morally appropriate response to an issue that affects every single county in Wyoming. These individuals who fill our jails in Laramie County, it's over 40%, and they are like mentioned, a resource kind of suck on the system, and they also impact the staff and other inmates. Aside from that, they're not getting the help that they need or that they deserve, quite frankly. I would encourage you, if you're available, to go to the Laramie County Jail. They will give you a tour while we wait for our mental health pod to open up. But the current situation is that many of these folks have to be held in the booking area, which is 24-hour lights with constant noise for months on end. And you can watch as these folks deteriorate past the point of redemption. And that is really, really a sad reflection upon all of us as a society, that's where we've taken this. And I'm happy to say that this bill helps us address, in a small way, a greater problem. And it's not the end-all be-all. There will still be, 40% of our inmates have some sort of mental illness. We can't take 40% into a diversion program, but we can take some of those low-level offenders and get them the help that they need. We've seen in Laramie County a jaywalking charge where someone was housed for almost 400 days. I believe our marshal rate is around $150 a day, and that's for just a base level inmate. So you can do the math on what that means. This is fiscally responsible for Laramie County to invest in this program with our funds. And so I'd hope that this committee would support it. It is not an expansion of government. It's an effective and efficient use of the government resources that already exist and the community resources that exist within all of our communities to make a difference in all of these people's lives. So thank you.
Thank you. Judge Chambers, Representative Bratton?
Thank you, Mr. Chairman. And did you say they were representing the county commissioners?
Yes, ma'am. So, Mr. Chairman, through you, sorry. Yes, Representative Bratton.
And do the county commissioners, they're aware and support that there's going to be additional costs to the counties, as was previously mentioned?
Mr. Chairman, through you, Representative Bratton, I believe, yes, we are in support because we have to opt in, right? Not every county is going to be able to take advantage of this for various reasons, but it is a tool in the toolbox that allows us to address issues that affect our community. And so I think that you will see a vast number of counties take this option.
Judge Chambers?
Mr. Chairman, members of the committee, thank you for having me. I'm Sean Chambers. I'm a circuit court judge here in Cheyenne. I don't have a great deal to add to things that have already been said, but 3 points I think that are important for me as a judge, and I think if I throw them out there, it'd be helpful to anybody that's unfamiliar with a treatment court program or a diversion court program and how they work. The first point is that these are 100% voluntary participation. Nobody is forced into a treatment court program or diversion program. Participants ultimately have to agree. I understand that there's some element of coercion, you know, if somebody, hey, you can get into this diversion program or this treatment program and, you know, receive these services. The alternative to that is jail. You know, that's sort of coercive. I understand that. But ultimately, the person has to make the decision themselves that, yes, I want to be in this program. And I think that's important because participation in these programs is rigorous. I think the Campbell County program now, they appear before the judge every 2 weeks. And I have a DUI court program that I run here in Laramie County. Participants start out once a week coming to court. And on top of that, there's 9 hours of treatment a week that's required. So participation in these programs is rigorous. And, you know, that somebody would volunteer, be willing to engage in these programs demonstrates a willingness and open-mindedness on those participants' part to change, to make positive changes in their life. And I think that voluntary component is there. I mean, I think we could all understand that that's a big part of recovery. You can't force recovery, whether it be for substance use issues or for mental health issues. You can't force that on anybody. Somebody must volunteer to participate. The second point I want to make is I think it's helpful to think of these programs as supervised probation. You think your standard probation is unsupervised. Somebody pleads guilty to a crime, they're placed on unsupervised probation that might require that they, you know, participate in some sort of education programs or maybe even some treatment component, but it's unsupervised. Once they're sentenced, they go off and have to do it themselves. If they don't do it, maybe they'll violate the probation, but it's unsupervised. They go out, they're trusted that they will do those things themselves. The next level is supervised probation, where somebody is sentenced to sign up with probation and parole. They have a probation officer, might meet with that probation officer once a month or quarterly, or, you know, depending how their probation is arranged. And through that probation officer, they're supervised, making sure that they are doing the things they should be doing and not doing the things that they should not be doing. And, you know, it's a level of supervision from the Department of Corrections for those individuals. Participation in a treatment court or a diversion court, I call it supervised probation. Again, I talked about the participants in my program start out coming to court once a week. They are essentially supervised through the treatment court team, which in any treatment court or any diversion court would consist of the judge, the program coordinator. So in my county, we have a couple of employees through the county that are the coordinators for our treatment court programs. The district attorney or county attorney, as the case may be, is required to be on that team. Public defender or a defense attorney is required to be on that team. Probation and parole, they do have a probation officer assigned to each participant. The treatment provider, so the counseling center, or whatever it is that the program contracts with, they are on the team. Many programs also have a law enforcement officer or some law enforcement component to that team. So if you're familiar with, say, a multidisciplinary team, that's involved in, have all these disciplines together to coordinate the needs of that individual, the needs of the participant, what they, housing services, all the different things that go to contribute to that participant's success, all those things are coming from the team. It's not one person, it's not one probation officer or one individual or anything directing these things. It's a team effort headed by the judge. The judge ultimately makes all the decisions. And I really think that multidisciplinary aspect, I think of it, that's the case management that really is the kind of the secret sauce to these things. More people involved in this team that are focused on the needs of the participants, really, that's where kind of, I think the miracles happen. You see real, enduring, lasting change in individuals. The last thing I want to point out, we talk about, these are particularly for the diversion programs, mental health diversion programs. These are low-level offenders that have treatable mental illness, whether they're the sort of 5 that are listed in the Campbell County program or the Florida model. These are low-level offenders. And if you'll forgive a cultural reference here, we're not talking about Hannibal Lecter, we're talking about Otis, right? Constantly in and out of jail, constantly, to the point that they almost have their own bed in the jail. And if you look at your own communities, your own towns where you're from, everybody here, I imagine, could think of that person or those people that, so-and-so is not taking their medication again, or so-and-so is out on the corner doing their thing again. I would guess that if Representative Filer, Representative Singh, Commissioner Malm, if we all got together and talked about Cheyenne, talked about Laramie County, I suspect that we would probably come up with or identify the same core group of people. Like, oh yeah, I've seen that guy at Walmart. I've seen that guy walking around downtown, or whatever it is. These are low-level offenders that are generally not violent, probably have issues with substances or alcohol. They're recurring. They commit criminal trespasses, disturbances, shoplifting. They take a candy bar and a soda from the convenience store. They, all the things that you see people do that are these jailable offenses. Yes, they are, but is it a good use of resources that these folks are certainly not receiving services in the jails? So, again, these are not violent folks. If you think about your community and the people that may cause disturbances in your town, or that may, during tourist season, these are the folks that you probably don't want there out and about, causing problems in your community and that kind of thing. So that's the population that the diversion programs are really focused on.
Representative Kelly, do you have a question?
Yes, Mr. Chairman, thank you. First, I appreciate the Mayberry reference, although it has made me feel my age this morning. I have a 2-part question about current circumstances. My understanding is, first of all, if I understand this correctly, there are people waiting longer incarcerated for evaluation and treatment than their sentence would have been for the misdemeanor of which they've been accused. And do you recognize any constitutional issues with holding people that long for such low-level offenses?
Judge, if you feel comfortable.
I'll take a swing at it, but that's a multi-layered problem, really. And on the one hand, if they are not competent and they can't plead, they can't, you can't plead guilty or no contest to a crime that you're not competent for. If you're waiting for placement in the state hospital, and Mr. Johansson will address those things, but the constitutional issues are multi-layered. That I think it's a huge problem if somebody's waiting placement and have been in jail 400 whatever days for a misdemeanor that has a maximum penalty of 180 days. It's a huge problem from many different directions.
All right. Representative Webb.
Thank you, Mr. Chairman. My question deals with, we talk about, the terms that are always used, severe mental illness, and we talk about the impact. This proposed bill has the definition of mental illness, which is much broader than severe mental illness. What are the unintended consequences if something like this should pass?
Not sure the judge is the best one for that question. Maybe you want to save it for Mr. Johansson. All right. Judge, did you say you had 3 points? You have one more? We're about 10 minutes till 9, and we got another bill after this.
I've made all my points. I would just say that the consequence might be that the person would get better.
Okay. Mr. Johansson, welcome.
Thank you, Mr. Chairman, members of the committee. Stephen Johansson, Director for the Wyoming Department of Health. Being respectful of your time, I'll keep my comments brief. Representative Webb, Lean, and Braden asked some good questions that I think I can address, or hopefully address. One area that the department oversees is the Wyoming State Hospital. There's two ways for individuals to make it to the Wyoming State Hospital. One is on the civil side through Title 25. These are non-criminals who have been deemed by a judge to be dangerous to themselves or others, and through a court hearing process, multiple court hearings, can be committed to the civil side of the state hospital. The other wing or program at the state hospital is what we call CJS, or Criminal Justice Services. This is the criminal forensic side of the state hospital, that individuals who have been charged with or have committed crimes and also may have an underlying mental health condition that contributed to that criminal behavior go through the Title VII process in statute. And that's where defendants can plead not guilty by reason of mental illness, et cetera. And that kicks off a process that's twofold. One is evaluation. So state hospital clinical staff evaluate the mental status of the offender at the time of the offense to determine a couple of things. One, if they were competent at the time of the offense. Two, if they are competent to stand trial. That evaluation process for the misdemeanants that we're talking about here typically, generally, almost always happens on an outpatient basis, either in the detention center or jail, or via video or telehealth. That takes about, on average, about a month, 30 to 40 days to complete that evaluation. And again, we're talking about misdemeanors. Let's assume that evaluation comes back that the person is not competent. There is a mental illness at play, and the judge now has the option to order a restoration service that Sheriff Harlan was talking about. That's an inpatient commitment to the Wyoming State Hospital in Evanston for restoration, basically for treatment services, so that the person can be restored psychiatrically to then be returned to the judicial system to face their charges. That's really the crux of what we're talking about with one element that this bill really helps is that we have folks who are, as Judge Chambers mentioned, low-level offenders, but have a very serious mental condition. 3 or 4 of those were listed: schizophrenia, schizoaffective disorder, bipolar, major depression. These are typically conditions that respond well to rapid treatment. We're not talking about longer longer term, sometimes lower acuity mental illnesses that don't respond well and really need protracted treatment. That's somewhat of a different population than we're talking about being eligible for diversion. So as Sheriff Harlan mentioned, you see it in Natrona County Jail, here in Laramie County Detention Center, as was described, Campbell County, virtually all of your detention centers will encounter an individual that is really, really self-harming, aggressive towards others. Use and consumption of excrement was mentioned. That's also common at the higher end of this acuity spectrum, and rapid treatment is what's needed. Unfortunately, with the volume that we see committed to the state hospital, we have a wait list, both on the civil side and the forensic Title VII side. It's not something we like, it's not something I like, but this wait time of generally right now between 4 and 6 months for admission to the state hospital is the time period that you're hearing about when someone is sitting in a detention center not receiving treatment. Why I think this bill is positive for these particular programs is it really supports the local energy that what has happened over the past 1 to 2 years with communities, with state support, judicial branch support, developing alternatives to treat these folks is really exciting, both in terms of providing access to treatment from our local community mental health centers, as well as medication that can be provided in the jail or in the community. This is a really, really positive development because, as was mentioned, it's more efficient for the state resource at the Wyoming State Hospital, where low-level offenders can be treated at home in their communities, not waiting these long amounts of time for what can often be, for one of these misdemeanors that we get after 4 to 6 months, a pretty short stay in the hospital. Some medication, therapy, some social coaching, social skills development, and then they're right back home. But without that community engagement, partnership with the community mental health center, the folks locally, we do see that recidivism. So these programs can be extremely effective, not only for the state hospital being more efficient, the jails in the staffing issues, the resource issues they have with this particular population. But ultimately, as Commissioner Malm mentioned, I think this is what we would all agree on, far, far better for the person, really on a moral issue.
Back to Representative Webb's question, where he said, this bill talks about mental illness as opposed to serious mental illness. Does it matter with the discretionary input of this program? Does it matter whether we call it serious mental illness or mental illness in this bill? And in terms of the numbers, population-wise, is it significant that we use mental illness versus serious mental illness?
Mr. Chairman, it's a good question to your question and Representative Webb's question. I think what was worked in the interim to put the definition that's already in statute of mental illness in this bill is appropriate for one primary reason. I think we all support local control and the tacit knowledge that folks have locally. So while that definition is somewhat broader than what's in the treatment court rules for these diversion programs of very specific higher acuity diagnoses, there are, as Judge Chambers mentioned, local folks know their local folks and who needs help. I think giving that discretion, but within the boundaries of the judicial branch rules, and then ultimately within the boundaries of the policy that local diversion court would set up is appropriate to me. Mr. Chairman, if I may, to address a question Representative Lean brought up earlier, of course there's a cost to treating folks. I want to remind the committee something the legislature did a couple of years ago was direct my department to fundamentally reform our community mental health system, how we pay for those services and who we prioritize. Basically now with a $100 million program that's in my department for community mental health and substance use treatment, we have 4 population groups that are prioritized. Acute psychiatric adults, so think Title 25 civil commitment. Criminal justice involved adults, so think about this population through Title VII, those with serious mental illness who encounter law enforcement or the judicial system, the local or state corrections system. high-needs kids and their families, so those that are in the DFS custody or really high-need social cases that DFS might be involved with, and then a high-need, low-income category. Those are the four priority populations that we now serve. The point being, of course, there's a cost when you're diverting someone into treatment. Who's paying for that treatment? The benefit here is that because we've prioritized the criminal justice or judicial involved populations through a program that already exists in the Department of Health, with that connection to a local community mental health center that we already contract with and pay, we can automatically prioritize this population without an additional appropriation for the state or from the state. So I see a lot of these parallel efforts over the last several years, judicial reforms taking place, your direction to reform the community mental health system, the rebuilding of the Wyoming State Hospital and the Wyoming Life Resource Center several years ago, which are my state facilities. These are parallel efforts around behavioral health that are now, in my view, intersecting in a really positive way. And a bill like this, which doesn't make a ton of changes, insert new programming or money, really codifies, I think, the flexibility that local communities, detention centers, law enforcement are looking for to better serve this population. With that, Mr. Chairman, happy to stand for any questions.
Thank you. We're at 9 o'clock committee, and we have another bill after this one, so keep our questions tight. Representative Kelly.
Thank you, Mr. Chairman. I've got background working with people with behavior and emotional disabilities, and the only certainty was our unpredictability at times. So we've got a backlog of people who clearly need some help. Why wouldn't there, however, with this expansive definition of mental health or mental illness, why wouldn't there be a potential for people manipulating the system and possibly delaying the process for those who need it by people who really don't qualify, but just taking a shot?
Mr. Johnson.
Mr. Chairman, Representative Kelly, it's a really good question. I could spend a couple of hours, and happy to do that offline with you. Maybe at the bar would be most appropriate. But to answer simply, of course, that's always a risk. I think the check on that with these types of programs and with the judicial system is what Ms. Butler mentioned, that this is not a program where an offender who commits a misdemeanor can say, oh, actually, I'd just like to do that diversion instead of my time or my sentence. There's a thorough evaluation at multiple steps of the process. One, which is relatively quick, that a jail staff can do that doesn't have to be clinically trained, to really get an early indication, does this person start to meet these definitions, where we think a more comprehensive mental health evaluation to actually determine that diagnosis is appropriate. And so that, I think, similar to Title 25, where a judge is also hearing on the civil side, I've got to make a determination if I'm going to commit someone to the state hospital and take civil rights away. I want to be clear as a judge on these diagnoses and see the evidence and see what type of evaluation and what was considered. Something similar happens with these diversion programs to really make sure you're targeting the folks that are most appropriate. On the other side of that, Representative Kelly, because your point resonates a lot with me, over the past several years, I've been with the department about 12 years, so in the last decade or so, generally speaking, 1/3 of my state hospital forensic bed capacity is occupied by misdemeanors. And I think that's an indication of an opportunity that we have as a state, where that doesn't mean those folks don't need service. But going through the analysis to determine at the state hospital, it's the highest restrictive level of care possible in a psychiatric setting. It's a locked facility. It's a tough facility to work in, tough facility to be in. I'm very proud of it. We have excellent clinicians there. But knowing that bed capacity is taken up and contributing to the wait time for law enforcement, for sheriffs, for other cases, is a really meaningful metric for me of how we could do things better, not only more efficiently, but more appropriate for those clinical needs of the folks that come to us.
Thank you, Chairman. So I looked into the presentation to the Vulnerable Adult Task Force that was Judge Matthew Castano gave and this data comes from the Substance Abuse and Mental Health Services Administration about the jail population of people with serious mental illness. And this, if the definition that is in this bill stays, it has the potential to increase this 81%. And so once I had that data, I actually started calling judges and asking them, what their thoughts were on this. And I'll tell you, the ones that are familiar with this program, who are supportive of this program, were startled to hear that the definition was changed to that. They absolutely thought this program was just going to be severe mental illness, at least initially. Those are my words, not theirs. They were very surprised, and even suggested they didn't even think it could be admin with the definition being changed to all mental illness. So can you care to comment on that?
And maybe the judge as well, because as I understand it, the rules aren't changing, the rules of the process, but we're changing the language in the statute. So either one of you want to chime in there?
Mr. Chairman, Representative Bratton, yes, that's right, and you're also right. I think there were the check against overwhelming volume coming into the program would be not only the administrative rules that govern when you take this broader definition of trying to help those with mental illness in the judicial system, which is that definition you see in Title 35, that is more expansive. Then the administrative rules of the judicial branch saying, if you're doing a diversion court, here's really the folks that we're looking for, coupled with then the local decision, if a community implements a diversion court, of who are we targeting. And that was my point earlier about you really want to focus on the types of diagnoses that are very responsive to rapid treatment in the short term. Absolutely, we have full agreement on that. I just think it's that cascade of, give you a good example, the Campbell County community and the community here really wanted to include the PTSD diagnosis there. And the programs we visited in Florida also had elements of that too. But I think from the clinical side, if you were to talk to my medical director at the state hospital, would say, well, be careful with that, because PTSD is a longer term treatment that you just want to be sensitive to. What are we trying to accomplish with a program like this? And it's really more rapid stabilization, then diversion from the court process because community treatment is there, and then a longer-term non-judicial treatment program that could be beneficial. So there's a range there, but again, I think it cascades, in my view at least, nicely, that broad direction is in statute, not micromanaging or specified, and that administrative rules and local control, local decision-making can govern that.
Thank you.
Okay, we're 5 after 9. I think there's others in the room. Thank you, all three of you, for being here this morning. Good morning. Please keep our testimony tight.
Thank you,
That's what we need to
Mr.
know.
Thank you, Mr. Chairman and committee members. Andy Somerville, Executive Director for the Wyoming Association of Mental Health and Substance Abuse Centers. And we stand today in support of the bill. There's been a lot of good discussion that I won't repeat, but I do want to talk a little bit about this conversation I'm hearing about the definition and the target population from a clinical point of view. So we've got the program that is concentrating on these 5 main criteria: affective schizophrenia, et cetera, because that's generally what we see, again, as described by Director Johansson and Ms. Butler, as the target population. One of the concerns we have when we talk about changing the definition of mental illness, and why we try to promote consistency in the statute, is because anybody who's ever studied the history of psychology knows that this is an ever-evolving science and an area. And I wanted to share with the committee that the most recent volume of the DSM, which is the Diagnostic and Statistical Manual for Mental Disorders, came out in 2013. That's the DSM-5. When they did that, they changed 6 entire classes of mental disorders, renamed a whole bunch of stuff. They added, they subtracted. There was a significant amount of changes just in the type of language that was used, how the diseases were classified, et cetera. The other thing that's important with the definition, when we look at the definitions that are in state statute, is there almost a description of function, right? As you read that it's a behavioral impairment, that they're having those issues. When we went through and the legislature passed a behavioral health redesign piece, there is a piece in there that talks about adults with serious mental illness. And it talks about that they will have trouble providing food, clothing, housing, basic day-to-day activities. Again, it's a level of functioning. So we're supportive of I think the narrowing in on the program in terms of clinically where we're concentrating most of our resources are at. But we would be remiss if we said that that was everybody that we could help. And as the community mental health centers, we're the treatment providers. They're providing the treatment, trying to stabilize these folks, trying to keep them from going back into the system. That's literally I think the charge, the most simplistic version of the charge I can give everybody from behavioral health redesign is the community mental health centers are supposed to divert folks away from going back to state institutions. If we significantly slim down that definition or put these 5 particular diagnoses in statute, I think we miss opportunities to consider one-off cases that may not be as common. But I think that, again, going back to the local communities and the counties know these folks. And the other experience that I would share is that these treatment teams, they're very, very picky. If you'll notice in the bill, the bill doesn't change the definition of substance abuse, but because this bill has both drug treatment court and mental health diversion court pieces in it, the substance use definition also refers back to that same substance abuse definition in statute in Title 35. And so we're not limiting that substance abuse definition. But as you go through those processes, if you've ever had an experience with drug court, just because you have a substance use disorder or an alcohol use disorder does not mean that you're going to go to drug treatment court. You have to pass a whole set of criteria. They are cognizant of their resources. They're cognizant, I think, of where they can best be effective with those resources. And so I think from our point of view, we would ask the committee to leave the definitions the way they are. And if the committee is concerned about overuse or anybody exploiting the program or potentially exploiting the system, and I do hear that, from a treatment provider standpoint, that's terrifying. We don't want to have a wait list for our services either, but we do want to help the people that we can help. I would recommend that the committee add a report back requirement to the bill to see if that would be an option to come back and we can look at the data and see if that's something that we need to further rein in. And I'd be happy at that time to give you another update on what the DSM-5 is calling things these days. Mr. Chairman, with that, I'd be happy to stand with questions.
Thank you. Questions, Ms. Somerville? Representative Lean?
Thank you, Mr. Chairman. On page 12, starting at lines 19 and running through 22, it talks about a second assessment. And I'm curious if in the DSM-5, it gives you a guideline for what is enough time that is passed from that first assessment to give a second.
Ms. Somerville?
Mr. Chairman, Representative Lean, so first I want to be absolutely clear with the committee. I hold no alphabet soup behind my name. So what I can tell you from what's been shared with me is that it depends on how the first assessment went and the particular diagnoses that came. At the community mental health centers, we reassess people every 30 days, sometimes 60 days, 90 days. We're providing updates and reassessing where they're at based on that. And I apologize, that's not super informative to your question, but.
Thank you. Mr. Thompson?
Thank you, Mr. Chairman. My name is Alan Thompson, the Executive Director of WASCOP, the Wyoming Association of Sheriffs and Chiefs of Police. We've heard a lot of testimony today from a lot of people a lot smarter than me, and I would just like to second the information that you provided, that our organization does support this, and also add that there are 20 other sheriffs and countless other chiefs that are looking to see the good work from these pilot programs in counties to see whether these programs can work in their communities. And we can't see that unless this bill passes and we move forward in that realm. And I'd be happy to answer any questions if you have any, Mr. Chairman.
Thank you, Mr. Thompson. Seeing none, thank you.
Thank you.
Mr. Winnie, keep it tight, okay? We're up against the clock.
I promise, Mr. Chairman. Bill Winnie, Sublette County. I'm also a member of the Veterans Subcommittee for Legal Aid of Wyoming. Not so long ago, Wyoming put in place veterans treatment courts, and I view this as pretty similar. And I would note that veterans treatment courts across the country turn out to be pretty successful. So subject to your questions, thank you.
Now that is tight testimony. Thank you, Mr. Winnie. Any questions, Mr. Winnie? Appreciate you being here this morning. Anyone else in the room on Senate File 160? Ms. Shaner, you're not on this one? All right. Anybody on Zoom? All right.
I have a question, but I'm not sure who can answer. Can I ask the question, then whoever has the answer.
A free-for-all. We like free-for-alls. All right, Representative Lean.
Thank you, Mr. Chairman. My question is for whoever may have an answer. You keep talking about a rule that sets in play who's treatable and who's not. My question is, who can change that rule and how often is it likely that it would be changed?
Ms. Butler, maybe you're the best on that one.
Mr. Chairman, Representative Lean, just to give you a little bit of background, so procedural rules are reserved to the judicial branch to adopt. And so when we have rules that govern the procedures of the courts, it goes through a number of different committees, usually made up of various stakeholders that are involved in whatever rule change we're looking at. And so I anticipate that if we had a rule change for diversion or treatment court, we would run that through. We have a behavioral health committee within the judicial branch, and we would work with stakeholders. And then ultimately, the adoption of rules is reserved to the Wyoming Supreme Court. So after that committee work, it would end up in front of the justices, and they would determine whether or not to adopt any rule changes. I would say the diversion court rules have not been changed since they've been adopted. I would think at this point in time, because we are still in the pilot stage, I don't want to tell you that it's never going to change because we are still learning about these programs. And so it's a possibility that those could change periodically. I don't have a time frame.
Ms. Butler, are fiscal constraints taken into account as you evaluate those rules?
Mr. Chairman, absolutely. We would have to look at any fiscal impact, not only to the state and to the judicial branch, but also to the counties. We want to be sensitive to their budgets as well.
Thank you. Representative Brady, we're up
Thank you,
against the
Mr.
clock.
Thank you, Mr. Chairman. I'm not sure if you can answer or not, but the question is, if this program in Campbell County was only in place about a year, and we're looking at quadrupling it, what are you looking at in the future?
So is the desire to expand to other counties being driven by the interest from those counties? Is that where this is coming from, or?
Mr. Chairman, Representative Brady, the answer to your question, Mr. Chairman, is yes. The desire to expand the way that we've expanded to both Natrona and Laramie counties is because at the request of those counties, they are interested in expanding. I can tell you as of today, we don't have any plans to expand to additional counties, and that is because we want to get some good data back. We want to understand how these pilots are going to work and make sure that what we're doing is effective before we look to expanding to additional counties.
Thank you. Senator Olson, you want to bring us home? Nope, no closing comments? We're going to close public comment. All right. Committee, what's your pleasure? Moved by Filer, second by Singh. Any amendments to the bill? I'm not going to do page by page. There's a lot of pages. Most of them are just the substance use disorder language changes. Any substantive amendments? Representative Bratton, you have an amendment? Ms. Bratton, Representative Bratton.
Thank you, Mr. Chairman. So on page 5, lines 13 and 14, delete that entirely and insert XIX. Mental illness means schizophrenia, schizoaffective disorder, major depressive disorder, post-traumatic stress disorder, or bipolar disorder is diagnosed by a mental health professional. This was the standing committee amendment that was in the Senate.
Okay. I see this has Chairman Olson's name on it.
Just had a run off. I made it simple for the
You want
staff.
comment on this, Chairman? We got to have a second. Yeah, we need a second. Second by Lean. Thank you for that.
Mr. Chairman, this amendment was ran in the Judiciary Senate Committee. We adopted it, we brought it out to the floor, and we heard from community providers that the definition may be problematic, so we chose not to adopt it as a standing committee. I think there's a couple of things in it. PTSD was already brought up, and I think there was a discussion about how broad that could be, just as an example. So, but this committee can do what it pleases with this amendment, but just know that we heard from, once we thought this was a good idea, we heard from those who were involved, and they said maybe it's not such a good idea.
Thank you. It had your name on it. I wanted to hear what you had to say.
Yeah.
All right. So further discussion on the amendment, Representative Filer.
Thanks, Mr. Chairman. On the amendment, I talked to the bringer of the amendment this morning, and we were kind of discussing some of this. But one thing I'm worried about when we put pretty much a definition and really narrowing the scope, I don't think we're thinking about, people with developmental disabilities that actually, from when they're younger, they move up into something that's other than one of these, but they also don't understand what they're doing. There might have some help with these mental services. So, mental illness too is, PTSD and all these other things, but drug and alcohol. I mean, when we start putting in all these, what mental illness really is, and we really narrow the scope, I think there's gonna be a lot of people that will not be able to use this type of treatment court in order to get their help and be out into society and maybe get the help they actually really need. So I don't believe narrowing it right now, Mr. Chairman, is the right thing to do. I think we allow the system that works where there is assessments, professionals actually go through and say, okay, yes, there is a disorder here or whatever it might be, and let those things go up to the court and allow those judges to make that determination, Mr. Chairman.
Representative Kelly.
Thank you, Mr. Chairman. The testimony we heard said the overwhelming majority of people that we're looking to help fall into these categories here. I understand we've got the discretion of the prosecutor. I do have my experience with people trying to manipulate rules and systems, and I do have a genuine concern that although they would be shut out of the program, they could create a backlog just at the gate. There could be, with this expansive definition of mental illness, people trying to manipulate the system, causing one more delay for the people who really need it. I think it might be more prudent to keep this more tightly focused, and we could revisit it later, and if there are too many people falling through the cracks, then expand it. I think it'd be more difficult to throw out that wide net and then later pull things back in if it is having these unintended consequences. So I don't think the amendment hurts the bill in any way. So I'll probably support it.
All right. Pierre, you have the amendment. Committee, you're all aware of what the amendment is on page 5, line 13 and 14. All those in favor of the amendment say aye. Aye. Those opposed, no. No. I think that has failed. Further amendments? Call the roll.
Representative Brady?
No?
Representative Breton?
No.
Representative Chestek?
Aye.
Representative Filer?
Aye.
Representative Kelly?
Aye.
Representative Lean?
No.
Representative Singh?
Aye.
Representative Webb?
No.
Chairman Washet?
Aye.
5 ayes, 4 noes, do pass.
Tell me the vote again, please.
5 ayes, 4 noes.
5 ayes, 4 noes. Do pass. Thank you very much. All right, committee, it takes us to Senate File 10. So Senate File 10 is another of our joint judiciary interim bills. This one is specific to a very narrow piece of law that deals with basically settlements on litigation. Representative Chestic, feel free to jump in here. That deals with when you have a minor who's eligible to receive a settlement or some type of payment, and there is no conservatorship, there is no guardian appointed, and it allows parents to accept payments. Presently in law, I believe it's $5,000, and this allows up to $25,000 in those types of settlements without having to have a guardianship or a lot of legal action. So basically, we're catching up with some inflationary, but also in just the reality of these types of settlements. If you have a minor, for example, involved in a motor vehicle crash, and the settlement offer is $20,000. Under existing law, we would end up in the court system getting a conservatorship or a guardianship and all sorts of things in order for the family to accept that $20,000 settlement on behalf of the minor. And so that was the genesis behind the bill. Ms. Shaner, do you want to chime in here at all? Or Representative Chestic, is that your recollection of the discussion over the interim? Ms. Shaner, welcome this morning.
Good morning, Mr. Chairman, members of the committee. My name is Marcia Shaner. I'm with the Wyoming Trial Lawyers Association. We joined the Joint Judiciary Committee throughout their interim work and did provide comments on this bill. It was brought the year before and was just time ran out, and so made it through one house but not through another. It is, as we say, a simple little bill. It changes the amount of money that can be, that a minor can receive without having a conservatorship formed, and also helps in that you don't need a lawyer in that outcome any longer, up to $25,000 instead of $5,000. I can give you one example in my family. My grandson was injured, he was 10, in a car crash, and received a $10,000 settlement for the injuries that he sustained, and his parents had to hire a lawyer, set up a conservatorship, and it took quite a little bit of time. And with this change, just bringing it up through inflation, his parents could have set up the vehicle that money was invested in for him. There are sideboards on here. You do have the ability or a cause of action by the minor to, if his parents don't manage his money and for his self-interest or for his benefit. But it's mostly just bringing us up to levels that are more today's numbers. Inflation has changed so many things, and as you know, most insurance minimums are $25,000, so that seemed like a good fit. So you minimize an extra legal step, you diminish costs, and it's more time efficient. So those are the reasons that we support the bill, and I'm happy to answer questions if I can.
Question for Ms. Shaner. Representative Lean.
Thank you, Mr. Chairman. Thank you for coming today. My question has to do with page 6, lines 5 to 7, where it talks about if there's a mismanagement of the funds. I'm just curious, the cause of action, does that have a time constraint on it?
Ms. Shaner.
Mr. Chairman, Representative Lean, I apologize, but I am not certain of that. I would imagine that there is a statute of limitations, but I'm not certain of what that is. Perhaps Representative Chestic could help us both.
Representative Chestic.
Thank you, Mr. Chairman. So partial answer to that question. The cause of action depends on, the statute of limitations depends on the cause of action, but the statute is told while the minor is still under the age of 18. So statute doesn't even start to run until they achieve the age of 18. So whatever the statute of limitations is would begin on your 18th birthday, and then you have those, whatever that period of time is to file this cause of action.
Thank you. Further discussion, Representative Singh.
Thank you, Mr. Chairman, and Ms. Shaner for being here today. Can you just talk to us as to why it is that we landed on $25,000 as compared to the $5,000 previously?
Ms.
Mr.
Shaner.
Chairman, Representative Singh, I think we looked at inflation to some degree. Also, I think the $25,000 minimum in auto insurance had a role to play in that number. And that's where I think we all felt comfortable at the end of the day in the discussions of increasing the number.
Okay, further questions? Seeing none?
Thank
you,
you.
Ms. Shaner. Anybody on Zoom? Obviously, there's no one else in the room. Committee, what's your pleasure?
Move the bill.
Moved by Chestic, second by Lean. Discussion or amendments? Seeing none, call the roll, please.
Representative Brady,
Aye.
Representative Breton,
Excused.
Representative Chestek,
Aye.
Representative Filer,
He left a vote of aye.
Representative Kelly,
Aye.
Representative Lean,
Aye.
Representative Singh,
Aye.
Representative Webb,
Aye.
Chairman Washut.
Aye.
8 ayes, 1 excuse. Do pass.
There is a vote from Bratton for aye.
I changed it.
I wasn't sure.
Anyone wish to carry this bill on the floor? Representative Lean.
Chairman, you could have started at 8 and still made it.
Yep.
I'm better than I know, yeah?
It's better safe than sorry, I got it.
I keep cracking the whip, and sometimes we finish early. So committee, just give everybody a heads up in terms of when we're going to be meeting. Representative Webb asked me over the interim during the summer. Our first meeting will be May 19th and 20th. May 19th and 20th, so you can move your doctor's appointments or whatever else you may need to move. May 19th and 20th, August 12th and 13th, and October 13th and 14th. The location of that May meeting has not been set and will likely be determined based upon our discussion of interim topics. For example, if we took up the forensic examinations of people at the state hospital, we might want to have our meeting in Evanston. If we wanted to take up something dealing with the boys' school, we might want to meet in Worland, that kind of thing. But the second meeting, I believe, is going to be in Cheyenne, and the October meeting's in Casper, or vice versa, something like that. So one's in Cheyenne, one's in Casper, and the first one is open to topics. Now, on March 3rd, next Monday at noon, we will meet jointly with the senators from the Senate Judiciary Committee to look at interim topic proposals. And the hope this year is that Management Council will give more leeway to the committees and the committee chairman on the selection of interim topics. In the past, Management Council was constraining, maybe say, in terms of interim topics. And sometimes they would give us other topics that the committee had not recommended. So we'll see where we end up on Monday, March 3rd, when we look at interim topics, but I just want to give everybody a heads up as to when we'll be meeting. Okay. And with that, we will stand adjourned. We have, I think, 3 bills for Wednesday, and Wednesday is the last day for Senate files coming to committee. So I think we'll start at 7:30 probably again on Wednesday, just in case. And I am, if it's open, if agreeable, going to ask the vice chair to chair that meeting. I'd like to give vice chair experience in terms of someday being ready to be a chairman. So Wednesday, the vice chair will be in charge for the whole meeting.
Mr. Chairman, just folks, we're going to keep that very tight when it comes to any sort of comments, so just letting you know. Thank you.